police attend at your house, knock on the front door, and you show up at the front door, and they placed you under arrest for assault. And you say, what are your grounds for this? Why do you do it? Why are you arresting me? Someone told me you committed an assault. Is that sufficient? That's hearsay when someone tells them something. Is that sufficient for the police to arrest? So that's the question for today. We break down common legal questions at Kruse Law YouTube channel. And this one is, can the police rely on hearsay to justify arrest? Well, the short answer is yes, they can, but it depends on the situation. Sometimes they can and sometimes they can't. I'm going to break down some common scenarios for you and some obvious ones and not so obvious ones, and we'll get to the point on this. So it has to be reliable, first of all, and sometimes the police have to corroborate the hearsay, and I'll explain what I mean as I go along. So let's take an obvious one. So let's say the police go and meet with a complainant on a domestic assault, your wife, and your wife gives a statement to the police that you assaulted her. That's hearsay to the police, isn't it? But it's a direct statement from your wife. But the complainant's told the police something. So clearly the police can arrest on that. Okay, so because your wife said that you committed the offense. So that's a pretty obvious situation where they have reasonable probable grounds based on what your wife told them. They're receiving the grounds, which is essentially hearsay, but her evidence is not hearsay in court. That's direct evidence. So let's take another situation. Let's say the police receive an anonymous tip that you're dealing drugs. Well, that's a very kind of unreliable, isn't it? It's just out of the blue. Crime Stoppers, they would have to corroborate that tip. They would have to get other information, other direct evidence against you, and use that tip as part of the arrest eventually. But they couldn't just arrest on that anonymous tip. Let's take a third situation. So they've got a reliable informant, drug informant they've used before. That drug informant has given them all sorts of details about your house, what's in your house, etc. That they've seen you with drugs in the house, drugs were in the other day. You could get a search warrant for that. So first of all, could they just arrest based on not finding the drugs? Could they arrest just based on the tip? No, they would have to get the search warrant. And if the search warrant produces drugs and the search warrant's found to be valid, well, there's a valid grounds for arrest. So the hearsay, if I might put it that way, from the informant form part of the grounds for the arrest coupled with the drugs, okay? Another situation. So a police officer has direct evidence. Let's say a police officer has direct evidence against you, and maybe two obvious situations, saw you committing a B&E going through a window. That officer can tell another officer to arrest you. They can give you the grounds. I saw them going through the window, arrest them. So another officer is receiving the hearsay, they can go arrest. So it really depends on the situation. Some hearsay has to be corroborated or confirmed as being reliable, like the anonymous tip situation. Even the informant situation, a reliable informant, has to be corroborated. You can't just arrest. Complainants, though, or who give their version of events and the police subjectively and objectively believe them, then have reasonable and probable grounds to arrest. And an officer can transfer his hearsay grounds to another officer to arrest. So there's 4 fairly obvious situations. There's all sorts of permutations and combinations. But the bottom line is that hearsay can form part of the grounds of arrest. It can form grounds to pull a car over, for example, like a citizen might get a report that, I should say the police might get a report that you were weaving all over the roadway. That's going to justify them pulling over your car. They're going to get further grounds and arrest you eventually, say for impaired driving. So the hearsay formed at least part of their grounds. But for pure hearsay to form part of the grounds, that's a more difficult situation. It has to be shown to be reliable and perhaps corroborated, confirmed. Like, to give you an obvious example, let's say the police interview your wife. Your wife said you punched her in the eye. The wife has a black eye. They've been told hearsay from the wife, who's eventually going to testify. It's not hearsay when she testified, but that's an obvious situation where they confirmed and corroborated the grounds. Now they can arrest you. They weren't at the scene of the crime. They're hearing it from another person, which to them is essentially hearsay, but that's forming part of their grounds. Again, your wife's direct testimony could convict you at trial. That's not hearsay. That's direct oral testimony at the trial. So there is a little bit of a primer, because clients are sometimes surprised that they can be arrested on hearsay. They're sometimes surprised that search warrants can be received for their home based on anonymous tips, which are slightly corroborated. By the way, the police rely on, number one, anonymous tips all the time, but they'll do further research, I should say, further investigation, perhaps to see people going in and out of your house too often in the middle of the night. This, coupled with the anonymous tip, may be enough to grant high electricity bills. This goes in a search warrant. They eventually find the drugs. So hearsay formed part of the grounds. So sometimes hearsay can form all of the grounds. Sometimes it can form part. Sometimes it's not reliable and it cannot be relied on. It really depends on the situation, and every situation is unique and has to be assessed by the courts. Because if the courts found that the hearsay was not corroborated or reliable enough, defense counsel could bring a Section 9 application for arbitrary detention and perhaps a Section 8 for unreasonable search and seizure, and then exclude the evidence under Section 24(2) because it just wasn't enough to form the reasonable and probable grounds for arrest. That's the test ultimately. Do the police have objective, reasonable, and probable grounds which they also believe themselves to warrant arrest? And that has to be on at least reliable hearsay at a minimum, okay? And that's at a minimum. If you don't have that, they've got to go further with investigation and get further grounds before they're allowed to arrest you. And I go through this with clients all the time because sometimes they're shocked at the level of hearsay in their case, which led to an arrest. And the police are allowed to, after an arrest, they're allowed to continue their investigation, by the way. They may get a confession, which solidifies their case, just as an example. So there you have it. It's a little bit of a primer. The takeaway from this is this: if you've been charged with a criminal offense based on hearsay grounds, you really need to consult with a lawyer to determine whether it was sufficient grounds and whether you might be able to bring a charter application to exclude the evidence as arbitrary detention, unlawful search and seizure, and exclude the evidence in trial and go from there. But that's the takeaway that I explain to clients over the years. So anyway, thanks very much for joining me today. It's been a fun day of doing a lot of videos today. And if you like this video, please like it and subscribe, and we'll see you in the next one. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.